basics of divorce litigation. Litigation is started by the filing of something called a complaint for divorce. When someone files a complaint for divorce, it is filed with the clerk of the court where the lawsuit is filed. That lawsuit is then handed to the other person being sued by someone called a process server. The person is handed a copy of the lawsuit along with something called a summons or service of process. This advises the person that they have 30 days in which to respond to the complaint that has been filed against them. When someone has been served with a complaint for divorce, they must file a written response within 30 days. In addition to responding to the complaint filed against them, they also have the right to file what is called a counterclaim. A person has a right to sue another person for any claim, and they have the obligation to file a counterclaim for anything that is connected with the complaint. So the lesson for anyone filing a lawsuit is the other person also has the right to sue back. That is the first phase of divorce litigation, the filing of the complaint, the answer, and the possibility of a counterclaim. The second phase of divorce litigation can be what is known as a temporary hearing. A divorce case can take a long time, so our court system allows for the court to intervene early on in the process to make sure that the parties are well taken care of during the pendency of the divorce. This is called the temporary hearing. These hearings are generally very abbreviated hearings and designed solely to hold the parties in what is called status quo until the court can hear the entire case. This means that temporary custody, temporary visitation, temporary support, and temporary alimony issues can be addressed by the court fairly early in the process, as quickly as 2 or 3 weeks after the filing of a complaint. The third part of the process is the process known as discovery. Discovery can take a pretty good amount of time, and it has a lot of elements to it. The basics of the discovery process are interrogatories or questions, requests for documents, subpoenas, and depositions. It is typical for parties to serve upon each other questions asking who the other person's witnesses might be, what their documents might be, what certain financial matters might be, and what facts might be necessary for the pursuit of their claim. It is also typical for parties to request documents from the other side. This would include documents that they might use in evidence and all kinds of financial documents such as tax returns, credit card statements, checking account statements, and the like. So each party has the right to make reasonable requests on the other for all relevant information. In addition, depositions can be taken. A deposition is where a person is called to a place before a court reporter who transcribes everything that is said. The deposition is a situation where the attorney has the right to ask a party any relevant question. The deposition is transcribed by the court reporter and may be used at a trial to impeach a person if they should say something different at trial. Depositions are very important parts of the discovery process and very critical parts of a trial. In addition to interrogatories, requests for documents, and depositions, each party has the right to issue subpoenas to third parties such as banks, lending institutions, car dealerships, things of that nature that will allow them to access financial records and other records of the other party. These subpoenas can be served upon third parties, and typically there is some kind of fee charged by the third parties to provide the information. Once the parties have completed what they regard as adequate discovery, that is, finding out what the other side might say or finding out what evidence they need to find out for their claim, the case proceeds on to trial. trial in divorce cases is held before a judge. A trial can last anywhere from a half a day to a couple of weeks. The important thing about trial for parties to understand is in most counties and in most states, it takes a long time before a court can get to your case for trial. In many places, it might be up to a year or a year and a half before you can get your case tried. One of the things about divorce trials is that 95% or even more than that do not actually go to trial. But if you have to go to trial, it is a very difficult process and requires thorough planning and research and thorough preparation by the attorneys and the clients to be properly prepared for the trial. So the divorce litigation process is a long process. It's a complicated process. And what usually happens is that the cases are settled before the entire process is completed. But many parts of the process do have to take place before parties have enough information to properly settle their case. Those are the basics of the divorce trial.